Silence, all stand.
Yes, Ms. Vanessa.
Your Honour, this is a public hearing into redress and civil litigation. There are no parties who have been given leave or sought leave to appear, and there will be no appearances at the bar table.
Thank you. You might need to adjust that microphone. You're not coming through it clearly.
Thank you, Your Honour.
Before we ask Ms. Vanessa to tell us about the processes today, there's just a few words that I need to say.
Thank you, Your Honour.
In January this year, the Royal Commission released its consultation paper on redress and civil litigation. The purpose of this public hearing, the 25th public hearing of the Royal Commission, is to enable invited persons and institutions to speak to the written submissions they have made to that consultation paper. Our terms of reference require us to make recommendations in relation to ensuring justice for victims through the provision of redress by institutions. The structure of the terms of reference and the way those words are placed in them is important, and I invite anyone who is interested to carefully examine how those terms of reference have been drafted. In our work so far, many institutions have acknowledged that their previous response to survivors has been inadequate. Many survivors have a pressing need for assistance, including effective and just redress. As I indicated when we released the consultation paper, it is for these reasons that the Commission has accepted that we should consider the issue of redress and make final recommendations in relation to it as soon as possible. When releasing the consultation paper, I also noted that a reading of our terms of reference indicates that there is agreement amongst all governments, both the Commonwealth and the states, that justice for victims requires appropriate redress. Our discussions with institutions confirm that every major institution also accepts that effective redress is required if victims are to receive justice. I also noted on that occasion that when considering the requirement for justice through redress, it is inevitable that the opportunity provided by the civil law for a victim to recover compensatory damages must also be examined. That is, civil litigation and any reforms to it must be considered at the same time as one is considering redress. The issues involved in redress and civil litigation are complex. The Royal Commission has undertaken an extensive program of consultation to ensure that we obtain and understand the views of those who are affected. We have published issues papers on civil litigation, redress schemes, statutory victims of crime compensation schemes, and towards healing. We have also held a coordinated program of roundtables involving governments, institutions, survivors and others. This consultation program provided us with considerable assistance in developing the consultation paper. Our work on redress and civil litigation has also been informed by the Royal Commission's work in private sessions and in public hearings. Commissioners have now spoken with more than 3,200 survivors in private sessions. Each private session reveals a unique personal story of betrayal of a child's trust with, for many, lifelong consequences. Many survivors speak of losing their childhood. Others speak of losing the benefits which come from a stable family and the rewards which come from personal and career achievements. Many survivors also speak of the experiences they have had in seeking redress or pursuing civil litigation, and of what they think would best help them to heal and live a productive and fulfilled life. These private sessions have helped us to understand many survivors' views of redress and civil litigation and their processes as they have operated to date, and many survivors' views of how they could be changed to better achieve justice for victims. Evidence has been given about redress and compensation in many of our public hearings. Some of our public hearings have had a substantial focus on these issues. Case studies in relation to the North Coast Children's Home, the Catholic Church's response to Mr John Ellis, and the Christian Brothers examined aspects of civil litigation in some detail. The case studies relating to Mr John Ellis and the Christian Brothers also examined aspects of existing redress schemes, as did case studies in relation to Towards Healing, the Salvation Army and the Melbourne response. Case studies in relation to the Parramatta Girls Training School and the Institution for Girls in Hay, the Retta Dixon Home and Beth Carr Children's Home also examined circumstances where no redress was offered. The consultation paper we released in January was informed by the public hearings and private sessions and by our extensive consultation program. We have received considerable input from many interested persons in response to the consultation paper. We have received formal submissions from over 250 organisations and individuals, and we have received comments through the online form from approximately 100 organisations and individuals. On behalf of the Commissioners, I express our great appreciation to all of those who took time to give us their views and participate in our consultation program. We are grateful, indeed very grateful, for all of their contributions. We also appreciate the contributions of all those who will speak during this public hearing and the time they are giving in accepting the Royal Commission's invitation to speak. We have not summoned anyone to appear at this hearing, and all those who speak will be doing so voluntarily. We appreciate their willingness to assist us in our work. This public hearing and all of the responses we received to the consultation paper will assist us in forming our final views and making our final report on redress and civil litigation, which we intend to do in the middle of this year. It is regrettable but inevitable that we could not invite everyone who has made a submission to speak at this public hearing. We could not invite even all of those who expressed a particular wish to speak. The approach we took to selecting who should speak is designed to ensure that those listening to the public hearing would hear from governments whose views are significant in assessing possible options for redress, including structure and funding, from survivor advocacy and support groups, who between them represent many survivors and broader groups of forgotten Australians and former child migrants, from groups who represent members of the stolen generations, and from organisations who have particular expertise in issues of importance to Aboriginal and Torres Strait Islander survivors, from a number of the largest faith-based institutions, and from other institutions that provide services to children. We have also invited a number of people with expertise in counselling and psychological care to speak on a panel during the course of this hearing. We were also able to include an organisation that advocates for children in out-of-home care, a number of legal organisations, the Insurance Council of Australia, and some individuals who have had particular involvement in the operation of redress schemes. There are many views and interests that need to be explored in this hearing. However, every submission responding to the consultation paper will be considered by the Royal Commission in developing our final report on redress and civil litigation. Unless they raise confidentiality or procedural fairness issues, all submissions will be published on the Royal Commission's website. Any interested person will be able to read any of these submissions, regardless of whether the organisation that made the submission is speaking at this public hearing. As I have said, we are concerned to hear the views of governments. The consultation paper particularly sought governments' views on a number of issues, including support for a single national redress scheme or state and territory-led schemes in which non-government institutions would also participate. The consultation paper also sought government's views on options for improving the provision of counselling and psychological care for survivors, as well as options for funding a redress scheme. We have received written submissions from the Commonwealth, New South Wales, Victoria, Western Australia, South Australia, Tasmania and the Northern Territory. We, however, did not receive a written submission from either Queensland or the Australian Capital Territory. We invited each government to speak at this public hearing, including those governments that did not make a written submission. Victoria, South Australia and Tasmania have accepted our invitation, and we will hear from each of them over the next 3 days. The other 6 governments have declined our invitation to speak. The consultation paper discussed the strong support for a single national redress scheme expressed by many survivor advocacy and support groups, as well as by many institutions. The consultation paper concluded that the ideal position for survivors would be a single national redress scheme led by the Australian Government and with the participation of state and territory governments and non-government institutions. However, the consultation paper also noted that the ideal position will be difficult to reach if the Australian Government does not favour it or if the state and territory governments do not favour it. Submissions from state and territory governments have expressed a range of views, from support for participating in negotiations for a national scheme to opposition to a national scheme and unwillingness to participate in a state scheme with non-government organisations. As I said, we will hear further from 3 state governments during this public hearing. The Commonwealth has not accepted our invitation to speak at this hearing. Its written submission is available on the Royal Commission's website. It seems clear from the Commonwealth submission that it does not support a single national redress scheme. Its submission refers to a number of concerns that it has about the complexity, time and resources that would be required to establish a national scheme, and the potential overlap with or duplication of state and territory schemes. It suggests that the time required to negotiate a national scheme would be frustrating to survivors and would undermine community confidence in the outcomes of the Royal Commission's work. It also seems clear from the Commonwealth's submission that it does not support an expansion of the public provision of counselling and psychological care for survivors, other than through improving survivors' awareness of existing services and their level of confidence in these services. Finally, in relation to funding arrangements, the Commonwealth submits that the Royal Commission should make recommendations that institutions must accept the legal, financial and moral responsibility for failing to protect children. The Commonwealth does not see itself as having a role as funder of last resort, and suggests that such a role would not be necessary if the redress scheme were designed to take account of the solvency of institutions and the resources available to them when the maximum payment available to any given claimant is set. These issues obviously need further exploration. The Commissioners are disappointed that, although our terms of reference suggest that the need for effective redress has been accepted by all governments, the structural approach that is overwhelmingly supported by survivor advocacy and support groups and by many institutions as being most likely to ensure a just, fair and consistent outcome for all victims, wherever they may have suffered abuse, is not presently supported by the Commonwealth. That said, we welcome the Commonwealth's view that institutions must accept the legal, financial and moral responsibility for failing to protect children. This will of course extend to the Commonwealth accepting responsibility for any children who were not protected while in the care of the Commonwealth Government. It will be apparent that all 6 Commissioners are sitting for this public hearing. All Commissioners were involved in finalising the consultation paper, and we are all responsible for determining the Royal Commission's recommendations on these issues. It is important that all Commissioners have the opportunity to hear oral submissions from and be able, if required, to ask questions of those invited to speak at this public hearing. This hearing will operate a little differently from our previous public hearings. Apart from the panel on counselling and psychological care, which will take place tomorrow, each of the organisations or individuals speaking have been told that they will have 10 minutes to speak to their written submissions without any interruption, and they will be told when their 10 minutes are up, if necessary. There will then be some 10 minutes for those speaking to respond to questions asked by Commissioners and Council assisting. Now, the 3 days does include an extensive program, and it will be necessary for us to listen attentively and for all of us to seek to understand all of the issues that are brought forward to assist the Commissioners ultimately to resolve the best solution, which will be included in our report in the middle of the year. Yes, thank you, Ms. Finnis.